Good day everyone, I am Adam Robert Lido, and today I will discuss the other functions of banks. In our previous discussion, it has been discussed that a bank is a financial institution where customers can save or borrow money. It also serves several functions, and that include exchange function. Exchange function. The exchange function of the banks is mainly about dealing with the international trade and domestic trade. Meaning to say, the exchange functions of the banks cover the local and foreign exchange. In local exchange function, banks handle clearing and collection of checks. Meaning to say, the checks drawn on banks within the city are the subject of interbank offsetting of balances. This system of settling balances is known as the clearing process. The check has to be cleared when a depositor deposits his check instead of encashing it. In foreign exchange function, banks also clear and collect instruments involved in the international network. Aside from clearing and collection processes, another foreign exchange function of the bank is to provide the means of payment for international buyers and sellers. Now let's define foreign exchange. Foreign exchange or forex is the conversion of one country's currency into another. It usually happens in a foreign exchange market. In other words, a currency's value can be pegged to another country's currency, such as the US dollar or even to a basket of currencies. Foreign exchange is handled globally between banks and the other financial institution. The foreign exchange market involves participants such as the banks and other financial institutions. Foreign exchange market. The foreign exchange market, also known as forex market, is a system which establishes an international network allowing the buyers and sellers to carry out trade or exchange of currencies of different countries. Kindleberger once said that the foreign exchange market is a place where foreign monies are bought and sold. It is merely a part of the money market in the financial centers, and it is not restricted to any given country or a geographical area. Thus, the foreign exchange market is the market for a national currency or foreign money anywhere in the world. There are three functions of forex market, namely the transfer function, credit function, and the hedging function. The first function of forex market is the transfer function. In performing the transfer function, the foreign exchange market carries out payments internationally by clearing debts in both directions simultaneously, analogous to domestic clearings. Meaning to say, the forex market majorly functions to exchange the currency of one country into another, and it facilitates international trade activities. Credit function. Another function of the foreign exchange market is to provide credit, both national and international, to promote foreign trade. Credit function is another significant function of the forex market, in which it provides credit facility at the time of making overseas payments through foreign bill of exchange to its maturity or execution. Hedging function. The third function of the foreign exchange market is to hedge foreign exchange risk. Hedging means the avoidance of a foreign exchange risk. The globally trading business entities can hedge the risk of currency fluctuations by adopting means like a letter of credit or forward contract. When we say forward contract, it refers to a 3-month contract to buy or sell foreign exchange against another currency at some fixed date in the future at a price agreed upon now. Now let's proceed to the advantages of forex market. First is the high leverage. A forex investor can avail the facility of leverage or loan of up to 20 or 30 times of his or her capacity for trading in the forex market. Another advantage is the international trade, and it enables other countries to facilitate the trade activities, and thus forex market is essential. Next is the trading option. For the speculators or traders, foreign exchange market is just like other financial markets where they can make money on short-term fluctuations in the currencies. Next is the flexibility. We know that the forex market is a 24/7 market and there is no minimum or maximum limit of the exchange amount. It provides the flexibility of investment or exchange to the traders. Next is the hedging risk. The forex market provides for hedging the risk of loss on currency fluctuations while carrying global business operations and trading in foreign currencies. Next is the low transaction cost. Since brokers are not very much entertained in the forex market, the transaction cost, called the spread, charged by the dealers is reasonably low if compared to other financial markets. Lastly, the inflation control. To maintain the economic stability in the country and control situations like inflation, the central bank maintains a forex reserve which consists of currencies of different countries around the world. Let's now discuss the disadvantages of forex market. First is the leverage risk. Leverage refers to loan, and forex market initiates the leverage of up to 20 to 30 times the investment capacity of the traders. This may lead to the loss of the entire amount of the investor. Another disadvantage is the counterparty risk. The forex is highly unregulated with no central authority for currency exchange or trading risk mitigation. Thus, it may encounter the risk of non-fulfillment of the obligations by any of the parties involved in such a contract. Lastly, the operational risk. Since forex is a 24 hours market, it is difficult to manage its operations by humans. As a result, the traders rely on the algorithms and trading desk spread, respectively, to safeguard their investment in their absence. Let's now proceed to the encashment of checks. What is a check? A check is a written, dated, and signed instrument that directs a bank to pay a specific sum of money to the bearer. In other words, check is a document that orders a bank to pay a specific amount of money from a person's account to the person in whose name the check has been issued. Check features include the date, the payee line, and the amount of the check, the payer's endorsement, and the memo line. There are three parties involved in a negotiable instrument like check, namely the payer or drawer, the payee, and the drawee. The payer or drawer is the person or entity writing the check. The payee is the person to whom the check is written, and the drawee is the bank on which the check is drawn. That's all. Thank you.
Good day. Icy Cris Bustamante from GSB FM3. So I will discuss the types of checks. So first is certified check. One example is a certified check which verifies that the drawer's account has enough funds to honor the amount of the check. In other words, the check is guaranteed not to bounce. So, it is usually a good way for reseller to feel more secure about the source of buyer's fund, because the bank will set aside the funds that a person is issuing to you. Therefore, you will sure that the money given to you is you will receive. For example of the certified check is if Jane buying a car that almost 100,000 to Lenny, and Lenny asked Jane to give her a certified check. Then Jane go to his bank to get the certified check made. Then the bank will ensure that Jane has at least 100,000 pounds and withdraw that amount from his account before giving him the certified check. Therefore, when Lenny goes and deposits the certified check in her account, she is guaranteed to receive the money as the bank was already set aside for her. So second is cashier check. Cashier check is guaranteed by the banking institution and signed by a bank cashier, which means the bank is responsible for the funds. This type of check is often required in large transactions, such as buying a car or house. It is a check that guarantees, and it has the cashier's signature and uses the bank pound rather than purchaser pound. A certified check and cashier check are all different kinds of bank checks, but they are all safer than personal check. However, they are not the same. Additional in certified check, it is a personal pound, while the cashier check, the pound is from financial institution. Then, number 3 is payroll check. Another example is a payroll check or paycheck, which an employer issues to compensate an employee for their work. In recent years, physical paycheck have given way to direct deposit system and other forms of electronic transfer. So, it is traditionally paper which the document is issued by an employer to pay an employee for services rendered or called as wage. Number 4 is bounce check. Bounce checks are when someone writes a check for an amount larger than what is held in their checking account. The check cannot be negotiated. This is referred to as a bound check. The check bound because it cannot be processed as there are insufficient or non-sufficient funds in the account. So, this is referred as bounce check because the check that was used for payment, it could not be processed because the check writer did not have sufficient funds available to fund the payment. The example of this is usually happen in issuing personal check. Okay, for example, John is buying a car from Sophia, so he writes a personal check for 100,000. Then, when Sophia goes to the bank to deposit the check into her account, then the bank informs that Jen has less than 10,000 in his account, so they are not able to process the check. So this is creating a risk for other sellers. Next is transaction. Transaction. A trust is an legal arrangement in which individual or trustor gives an authority to control the property to a person or individual trustee for the benefit of the beneficiaries. So the property mentioned are such as house, life, insurance policies, investment, and other possession that gives to a person or individual who call as trustee, and you as a trustor you decide who receive the asset inside your trust. Typically, your spouse, your children, grandchildren, and charities of your choice are the beneficiaries. So it is a trust function where the settlor are having an agreement to a trustee. Then the trustee works in to ensure that all asset or of settlor is being processed to give by beneficiary. So this is essential element of a trust. A parties to the trust. So first is the trustor, guarantor, or creator. The trustor is an individual that creates the trust and normally places the original asset into the trust. Then it is said that the person who have disability is under a legal to sell or donate a property. This person, such as minor or a mentally disabled person, could not be a trustor. So next is the trustee. The trustee is a person or institution where the task is collecting all of the assets in the settlor and manage them until the trust entrusts them to distribute them to be a beneficiary. So next is beneficiary. Beneficiary is a person, group of people, or organization to which a gift of an asset made. The trustor can be also a beneficiary and the other persons such as spouse and children and so forth. Trust property. So the trust property are the assets which have been placed into a fiduciary relationship between a trustor and trustee for a designated beneficiary. Trust property may include any type of assets such as cash, life insurance, and so forth.
Good day everyone. My name is Marianne Tejada from BSBA FM3 and my topic is all about kind of trust. First, individual trust. Number 1, voluntary or living trust. Under this setup, the owner transfers the titles of the property to a trustee and gives instructions on how to dispose of the income or how to reinvest the funds. Sometimes known as inter vivos trust, is one made by a trustor or grantor during his or her lifetime, with assets or property intended for the individual's use during their lifetime. This type of trust allows the trustor to benefit from the trust while alive, but passes the assets and property on to beneficiary or using a trustee upon their death. With a living trust, you are generally able to avoid probate court, provided the trust is funded. Voluntary trusts are often used in estate planning. In the situations of real estate, the person who controls the real estate property is known as the trustee, while the individual who will receive the property after it is being held is known as the trustor. Number 2, testamentary trust. As its name implies, it is trust whereby the trustor transfers his property in trust through his will and testament, and this is to take effect only upon his death. It is a part of the will and testament itself and it is not separate legal document. An agreement made for the benefit of a beneficiary once the trustor has died, and details how the asset must be endowed after their death. This type of trust is often instituted by an executor, who will manage the trust for the trustor's descendants after their will and testament has been created. The difference between a testamentary trust and a living trust is that a living trust goes into effect when a settlor signs the trust, has it notarized, and then transfers property into that trust. This kind of trust is called a living trust because it goes into effect while the settlor is still alive. Living trust can be made to be either revocable or irrevocable. The term testamentary is the major difference between a testamentary trust and living trust because the very term means that the trust becomes active upon the settlor's death. Number 3. Insurance trust. This service is rendered whenever the trust department of a bank is appointed as trustee under insurance trust agreement. An insurance trust allows the trustor to combine their life insurance policy within the trust, keeping it free from taxation on the state itself. This kind of trust is irrevocable and doesn't allow the trustor to change or borrow against the life policy itself, but allows the life policy to help pay for post-death expenses on the estate. An insurance trust is an irrevocable trust set up with a life insurance policy as the asset, allowing the grantor of the policy to exempt assets away from his or her taxable estate. Once the life insurance policy is placed in the trust, the insured person no longer owns the policy, which will be managed by the trustee on behalf of the policy beneficiaries when the insured person dies. Fourth, Employee Benefit Trust. It is designed to provide benefits for the employee. An investment plan where funds contributed by an employer and an employee are held in a trust. It is usually applies to retirement plans because most other employee benefits are services that the employer pays as they are used. An employee benefit trust is an investment plan where funds contributed by an employer and an employee are held in a trust. It is usually applies to retirement plans because most other employee benefits are sa- are, ser- are services that the employer pays as they are used. The employer is usually considered the grantor and the employees are the beneficiaries of the employee benefit. I repeat, the employer is usually considered the grantor and the employees are the beneficiaries of the employee benefit trust. Fifth, investment management services. Management the investment portfolio is allows to clients' asset to grow in a disciplined manner with goals and time frame. Investment management refers to a handling of financial assets and other investments, not only buying and selling them. The management includes devising a short or long-term strategy for acquiring and disposing of portfolio holdings. It can include banking, budgeting, and tax services and duties as well. Investment management services include asset allocation, financial statement analysis, stock selection, monitoring of existing investments, and portfolio strategy and implementation. Investment management may also include financial planning and advising services, not only overseeing a client's portfolio but coordinating it with other assets and life goals. Second kind of trust, corporate trust. First, collateral trust. A collateral trust bond is a bond that is secured by a financial asset, such as stock or other bonds, that is deposited and held by a trustee for the holders of the bond. The bond is perceived as a safer investment than an unsecured bond since the assets could be sold to pay the bondholder. If necessary, a corporate bond is a bond issued by a company to raise capital for its short-term debt obligations or long-term debt capital projects. In return for the loan provided by investors, the company pays periodic interest to bondholders and upon maturity of the bonds, repays the principal investment because companies prefer to issue debt with as low an interest rate as possible. They will seek out ways to reduce their cost of borrowing. One way to do this is by securing the bond issued with collateral through a security called a collateral trust bond. Second, sinking fund. Sinking fund accumulated and set aside by a corporation or government agency for the purpose of periodically redeeming bonds, debentures, and preferred stocks. The fund is accumulated from earnings, and payments into the fund may be based on either a fixed percentage of the outstanding debt or a fixed percentage of profits. Sinking funds are administered separately from the corporation's working fund by a trust company or a sinking fund trustee. A sinking fund is a strategic way to save money by setting aside a little bit each month. Sinking funds work like this. Every month, you'll set money aside in one or multiple categories to be used at a later date. With a sinking fund, you save up a small amount each month for a certain block of time before you spend. Trust activities of the banks. These are the trust activities of the banks. Number 1. To act a trustee for a corporation's asset under mortgage, bond, or issues. Number 2. To act as the transfer agent or registrar of stocks and bonds. Number 3. To act as a guardian of minors' interest. Number 4. To act as the executor of last will and testaments. Number 5. To act as the administrator of states. Number 6. To act as a depository for escrow deposits and other securities. Number 7. To act as a signee, receiver, or depository. Number 8. To act as an advisor. Thank you for listening.
Good day everyone, I am Angielyn Mitas from FM3, the port reporter of group number 5, and my topic is all about the advantages of having a bank serves as your trustee. But before that, let me first answer the question why banks make better trustee. So in order to answer these questions, when planning your estate, one of the tools that you might consider is some form of trust. First is the revocable trust, second is the irrevocable trust, and last is the testamentary trust. In any of these instances, you must consider whom to name as trustees or co-trustee of the trust. The trustee can be one individual, multiple individual, an institution, a bank or trust company, or combinations of an institution and one or more individuals. So let's proceed to the advantages of having a bank serves as your trustee. So first one is the professional management. When a bank serves as trustee, people in the bank's trust department manage the trust. So the management of the trust is full-time job of these people. The trust officers are professional trustees experienced in the requirement and appropriate procedures for administering a trust. An individual trustee, no matter how knowledgeable, is generally an amateur trustee. The bank brings experience and knowledge in investment generally and trust investment in particular. The bank trust officer will be aware of all these items and will act accordingly. So next is the second advantage of having a bank serves as your trustee was the objective exercise of discretion. The bank trust department deals with these types of decision every day. The decision can still be difficult, but the bank is well equipped to handle it. So it is often difficult to be objective, particularly where different beneficiaries have different and opposing interests, or where emotional relationships are involved. For example, exclusively in tax-free municipal bonds, your trustee has to exercise discretion to reach a fair compromise between the interests of all beneficiaries. More precisely, it might be appropriate under certain circumstances to seek to convert the trust to the unit trust to eliminate this conflict between the different beneficiaries. So let's proceed to the third advantage, which is the avoiding conflicts of interest. An individual trustee might have an inherent conflict of interest if he or she is also a potential beneficiary, but a bank trustee would have no such conflict. So for example of this is the situation, assume that you name your brother George as a trustee of your child. Also assume that the trust provides that if your child does not survive the term of trust, George's children become the beneficiaries. Thus, the more trust pounds that George spent on your child, the less there might be left for his own children. If your child dies, this is classic conflict of interest. George might be inclined to be fragile when using trust pound for your child, contrary for your intentions, because he is also considering the interest of his own children. However, the bank trustee would have no such conflict. So the last advantage of having a bank serve as your trustee was the protection against misappropriation of pounds. There are numerous examples of individual trustees who have stolen money. If a bank is named as trustee, the likelihood of misappropriation is reduced because of checks and balances in the administration of the trust. However, even if there is a dishonest trust officer, the bank, presumably a financially secured institution, that will be standing behind its trust officers and make good any losses that result from dishonesty of the trust officer. So, as a summary of this, not every trust is a good candidate to have a bank serve as trustee. However, a person considering using a trust as part his or her estate plan should not simply dismiss the notion of naming a bank as trustee or co-trustee. In addition to that, a careful considerations of both the advantage and disadvantage should be made before any decision is made. Also, when discussing the use of the trust when you're a lawyer, you should also discuss the disadvantage and advantage before making a final decision. And that's all. Thank you.
Good day everyone, I am Marianne Grande and I will discuss about the regulation of trust companies. But first, let me define what trust company is. A trust company acts as the trustee for businesses and individuals to provide estate plannings and other related financial services. Trust companies often are commercial banks that may act as stock registrar and distribute dividends for companies, as well as wills and estate for the individuals and administer corporate pensions, plans, and bonds for businesses. Trust companies typically are regulated by the state law, and here are some examples of regulations of trust companies. The first one is the Section 79 Authority to engage in trust business. Here, it stated that only a stock corporation or a person duly authorized by the Monetary Board to engage in trust business shall act as a trustee or administer, wherein trustee defined as the individual that is given control over the assets left in the trust, and this person's primary role is to act in the best interest of the beneficiary, wherein the purpose of this act, such a corporation shall be referred to as a trust entity. Next one is the Section 80, Conduct of Trust Business. In this section, a trust entity shall administer the funds or property under its custody with diligence that a prudent man would exercise in the conduct of an enterprise, if a like character and with similar aims. Where there is no trust entity shall, for the account of the trustor or the beneficiary of the trust, when it comes to purchase or acquire property, assign or lend money, purchase debt instrument unless the transaction is especially authorized by the trustor, and the relationship of the trustee and other party involved in the transaction is fully disclosed to the trustor or the beneficiary of the trust prior to the transaction, where the Monetary Board shall promulgate such rules and regulations to prevent circumvention of the evasion of the responsibility herein imposed on a trust entity. Next one is the Section 81, Registration of Articles of Incorporation and Bylaws of Trust Entity. In Section 81, the SEC or the Securities and Exchange Commission shall not register the articles of incorporation and bylaws or any amendment of any trust entity unless it is accompanied by a certificate of authority issued by the PSP or the Bangko Sentral ng Pilipinas. Next one is the Section 82, Minimum Capitalization. Here, it stated that a trust entity, before it can engage in trust or other fiduciary business, it shall comply first with a minimum paid-in capital requirement, which will be determined by the Monetary Board. The main duty of a trust company is to manage money where they typically chartered to serve as executors, agents, trustee, or custodians of financial for the individual and businesses. The general fiduciary laws regarding to accepting accounting practices, amount of fees allowed, and investment abilities also pertains to trust companies. Next one is the Section 83, Power of a Trust Entity. In addition to the general power incident to corporation, a trust entity shall have the power to act as a trustee or any mortgage or bond issued by any municipality, corporation, and to accept and execute any trust consistent with law. Next is to act under the order or appointment of any court as reserver, guardian, trustee, or depository of the estate of any minor or other incompetent person, and as receiver and depository of any money paid into court by parties to any legal proceedings. Also, to act as the executor of any will when it is named the executor. To act as administrator of the estate of any deceased person when there is no will. To act and execute any trust for the management and administration of any estate. And lastly, to establish and manage common trust funds subject to such rules and regulations as prescribed by the Monetary Board. Next one is the Section 84, Depository for the faithful performance of trust duties. Here in Section 84, Trust companies are required to have a capital before they can open their doors. Every trust entity shall deposit with the BSP as security for the faithful performance of its trust duties. Cash or securities that are approved by the Monetary Board in an amount equal or not less than 500,000 pesos or higher amount as may be fixed by the Monetary Board, and the amount depend on the type of trust company before transacting a trust business. Next one is the Section 85, Bond of Certain Persons for the Faithful Performance of Duties. Here, it stated that before an executor, administrator, guardian, trustee, receiver, or depository appointed by the court enters upon the execution of his duty, he shall, upon order of the court, file a bond in such sum as the court may direct. Upon the presentation of proof to the court that the subject matter of the trust has been deposited with a trust entity, the court may order that the bond given by such persons for the faithful performance of their duties be reduced to such sums as it may deem proper. Property deposited with any trust entity in conformity with this section shall be held by such entity under the orders and direction of the court. Next is the Section 86, Exemption of Trust Entity from Bond Requirement. In this section, no bond or other security shall be required by the court from a trust entity for the faithful performance of its duties as court-appointed trustee, executor, administrator, guardian, receiver, or depository. However, the court may, upon proper application, with it showing special cause. Therefore, it required to the trust entity to post a bond or other security for the protection of funds or property confided to such entity, wherein the BSP shall have the full authority to regulate the use of electronic devices such as computers and processes for recording, storing, and transmitting information or data in connection with the operation of a banks, including the delivery of services and products to customers by such entity. Next one is the Section 87, Separation of Trust Business from General Business. In this section, it stated that trust business and all funds, properties, or securities received by any trust entity as executor, administrator, guardian, trustee, receiver, or depository shall be kept as separate and distinct from the general businesses, including all other funds, properties, and assets of such trust entity. Also, the account of all such funds shall be kept separate and distinct from the account of general business of trust entity. Next one is the Section 88, Investment Limitations of a Trust Entity. Here, it stated in these sections that unless otherwise directed by the instrument creating the trust, the lending and investment of funds and other assets acquired by a trust entity as executor, administrator, guardian, trustee, receiver, or depository of the estate of any minor or other incompetent person shall be limited to loans or investments as may prescribed by the laws and Monetary Board. Next one is the Section 89, Real Estate Acquired by a Trust Entity. It stated in this section that unless otherwise specifically directed by the trustor or the nature of the trust, the real estate acquired by a trust entity in whatever manner and for whatever purpose shall be governed by the relevant provisions of Section 52 of this act in which a bank may acquire, hold, or convey real property. Next one is the Section 90, Investment of Non-Trust Fund. In Section 90, the investment of funds other than trust funds of a trust entity, which is a bank, financing company, or an investment house, shall be governed by the relevant provisions of this Act and other applicable laws. Next is the Section 91, Sanctions and Penalties. Here, once a trust entity or any of its officers and directors found to have willfully violated any pertinent provisions of this Act, they shall be subject to the sanctions and penalties provided under Section 66 of this Act, where if the offender is a director or officer of a bank or trust entity, the Monetary Board may also suspend and remove such director and officer, while if the violations is committed by a corporation, that corporation may be dissolved by the quo warranto proceedings instituted by the Solicitor General. Next one is the Section 92, Exemptions of Trust Assets from Claims. In this section, it is stated that no assets held by a trust entity in its capacity as trustee shall be subject to any claims other than those of the parties interested in the specific trust, because the BSP may charge equitable rates as may prescribed by the Monetary Board for supervision, examination, and other services which is rendered under this Act. And lastly is the Section 93, Establishment of branches of a trust entity. Here, in Section 93, the ordinary business of a trust entity shall be transacted at the place of the business specified in its articles of incorporation. Such trust entity may, with prior approval of the Monetary Board, establish branches in the Philippines, and the said entity shall be responsible for all the business conducted in such branches, to the same extent and in the same manner as though such business had all been conducted in the head office. And the purpose of this Act is that the trust entity and its branches shall be treated as one unit. And that's all. Thank you.